The Fourth Amendment to the United States Constitution is supposed to protect each and every one of us from unreasonable searches and seizures.
So if the police ask you if they can come into your house and you don't want them to come into your house, then simply don't consent.
The Supreme Court rules that cops do not need a warrant to search your home. Another devastating blow to our freedom.
After all, if someone's bleeding out, no one wants a paperwork-first constitution.
Simply make it clear to them that you're not consenting to them coming into your house, but if they insist on coming in, stand aside and let them do their thing.
So you're sitting in your own living room, maybe having a rough day, maybe just keeping to yourself, and suddenly there's a knock at your door. Then you hear it. Police, welfare check, open up. You didn't call anyone, you didn't ask for help, you have no idea why they're there. But you know your rights, right? You know the Fourth Amendment says your home is supposed to be sacred ground, so you decide not to answer. And that's when things get terrifying, because what happens next, thanks to a brand new Supreme Court ruling, might completely change what you thought you knew about your rights inside your own home. Here's what most people don't realize. In January of 2026, the United States Supreme Court issued a decision that fundamentally altered how police can enter your home, and they did it under the disguise of something that sounds completely harmless, a welfare check. But before we get into exactly what happened and why this should concern every single person watching this, we need to understand what the Fourth Amendment was actually designed to do, because that's the only way you'll grasp just how significant this shift really is. The Fourth Amendment to the Constitution says, plain as day, that you have the right to be secure in your person, your house, your papers, and your effects. It says no warrant shall be issued without probable cause, supported by oath or affirmation, describing specifically the place to be searched and the things to be seized. That language isn't vague, it isn't ambiguous, it's direct. And for most of American history, that meant something very specific when it came to your home. If police wanted in, they had to go to a judge, lay out the facts, demonstrate probable cause, and get a signed warrant. The judge acted as a circuit breaker, a constitutional checkpoint between the government's power and your front door. That system wasn't perfect, but it was the system. And your home sat at the very top of the protection hierarchy. Now, there has always been one exception that everyone acknowledged made sense. If there's a genuine emergency, if someone is actively bleeding out or in immediate mortal danger, nobody expects officers to fill out paperwork while a life slips away. That emergency aid exception has existed for a long time. But here's where things get deeply troubling, because this new Supreme Court case took that narrow exception and stretched it so wide that the original rule barely matters anymore. Let me walk you through exactly what happened, because the facts of this case tell you everything you need to know about where this is heading. A man named William Cassiers was living in Montana. His ex-girlfriend called 911 and told dispatch that he was threatening suicide and may have already shot himself. Police responded. They arrived at his home, knocked on the door, and yelled through an open window. No response. So they started peering through the windows, and here's what they saw. Some empty beer cans, an empty handgun holster, and a notepad that they decided to interpret as a possible suicide note. Now, depending on who you are and how you live, that scene could describe half the homes in America on any given weekend, but the officers decided this constituted an emergency. And here's the part that should make you sit up straight. If this was truly an emergency, if they genuinely believed a man had shot himself inside that house, you'd expect them to act immediately, right? That's what emergencies demand. Seconds matter. But that's not what happened. Instead of rushing in, they called their chief. They had a conversation about strategy. They expressed concern that forcing entry might spark a confrontation. They then suited up with ballistic shields and long-barrel firearms. And from the time they first arrived to the moment they actually entered that home, 40 minutes passed. 40 minutes. That's not an emergency response. That's a tactical operation. But the court said it was still justified under the emergency aid doctrine. So what happened once they got inside? Cassiers was in a bedroom closet. He threw open a curtain holding something that appeared to be a weapon. An officer fired and injured him. A handgun was found nearby. And here's the twist that should disturb everyone. The police entered that home claiming they were there to save a life, but the entire encounter ended not in a rescue but in a criminal prosecution. Cassiers was convicted of assaulting a public servant. The so-called rescue mission became a criminal case, and this is where the Supreme Court's actual ruling becomes the most dangerous part of the entire story. The court held that police can enter your home without a warrant to render emergency aid if they have, and this is their exact language, an objectively reasonable basis for believing someone inside is seriously injured or facing imminent serious harm. On the surface, that might sound responsible, but buried inside that standard is a seismic shift that changes everything. The court explicitly said that this standard does not require probable cause. Let that sink in for a moment. The Fourth Amendment, the one we just read, the one that specifically uses the words probable cause, has now been interpreted by the highest court in the land to allow entry into your home without meeting that threshold. And when Cassis's lawyers challenged the court to define what objectively reasonable basis actually means if it's not probable cause, the court essentially responded by saying it means what we say it means, and we don't need to explain further. Now you might be thinking, come on, how different can those two standards really be? The answer is enormously different, and here's why. Probable cause forces police to answer hard questions. Who provided the information? How reliable is that person? What facts were independently verified? What specific evidence supports the belief that a crime occurred or someone is in danger? Those questions create accountability. They create a paper trail. They require scrutiny before action. But this new standard of objectively reasonable basis is intentionally vague. It's squishy, it's malleable, and most critically, it gets evaluated after the fact, not before. Under the old system, a judge stood between the police and your front door. That was front-end accountability. Under this new framework, the judge only reviews what happened after your door has already been breached, your home has already been searched, and your life has already been turned upside down. That's back-end forgiveness. And you cannot undo the damage once officers are inside your home. You can't unring that bell. But the real-world implications go even further than the legal standard itself. The court tried to frame this as non-criminal and non-investigatory. It's just a wellness check, they said. But once police are physically inside your home, two things happen almost every single time. First, the plain view doctrine kicks in. Anything officers see while they're inside, whether it's related to the original welfare check or not, can become evidence. That prescription bottle on the counter, that firearm in the corner, that substance on the table, all of it becomes fair game. What started as "we're just here to help" transforms into probable cause for a full-blown investigation. They secure the scene, they call for backup, they toss the house, and they build a case from whatever they find. Second, the narrative in the police report starts to drift. It always begins with concern for safety, but by the time the report is written, it reads like this: "We entered to render aid, we observed suspicious items, we feared for our safety, we detained the individual, we conducted a further search, and we discovered additional evidence." This isn't speculation. This is standard operating procedure. This is how officers are trained to document encounters once they're inside a residence. And now we arrive at what might be the most ominous aspect of this entire decision. Justice Sotomayor wrote a concurring opinion that reads almost like a warning label. She pointed out that the risk of escalation during these entries is significantly heightened when firearms are present in the home, and she noted how common gun ownership is in American households. Think about what that means in practice. Your neighbor, the one who doesn't particularly like you, calls the police and says something like, "I'm worried about the guy next door. He seemed really down lately, and I know he keeps guns in the house." Even if every single one of those firearms is legally owned, properly stored, and has absolutely nothing to do with anything, in the eyes of responding officers under this new standard, that information becomes a risk multiplier. It justifies a harder, more aggressive approach. Ballistic shields, long guns, tactical entry. Your constitutional protections effectively shrink because you own something you have every legal right to own. That should trouble every single person, regardless of where you stand on any political issue. And it gets worse for people experiencing mental health crises. Sotomayor specifically warned that individuals with serious mental health conditions are disproportionately harmed during police interactions. So now we have a collision of realities set in motion by this decision. Mental health situations are inherently unpredictable. Police are trained for control and threat neutralization, not de-escalation in confined emotional spaces. The home is the most personal, emotionally charged environment possible, and the legal standard for entering that space just became easier to satisfy than at any point in American history. That combination is how tragedies happen in living rooms. So does this ruling have any limits at all? The court says emergency aid entry doesn't authorize a full rummage through your home, but the real protection of the Fourth Amendment was never just about preventing searches once police are inside. It was about requiring them to stop at your threshold, go to a judge, present facts under oath, and obtain permission before crossing that line. This decision makes that requirement completely optional in any situation where police can articulate a reasonable belief that someone inside might need help. But here's what you actually need to know to protect yourself, because knowledge without action is useless. If police ever show up at your door claiming a welfare check, there are specific steps you can take to limit their ability to enter your home. First, and this is something you should do long before any police encounter ever happens, tell the people in your life what to do if you go quiet. A huge number of these welfare checks begin because someone who cares about you panics when they can't reach you. Make it clear to your close contacts, "If I'm not responding, try calling me first, then call someone else we both know." Then contact a crisis resource line. Calling the police should be the absolute last resort, reserved only for situations where there is genuine, confirmed, immediate danger. Second, if you own firearms and people in your life know it, understand that any welfare check at your home is likely to escalate far beyond a casual conversation at the door. When officers believe there are guns inside, their approach changes dramatically. Be prepared for that reality. Third, and this is critical, if police are actually at your door, communicate without opening it. You have no legal obligation to open your door. But here's the counterintuitive part. Remaining completely silent actually feeds the emergency narrative. The longer you stay quiet, the more justification officers have to claim they believe something was wrong inside. So speak through the door, pull back a curtain and make eye contact through a window. Let them see you're alive and coherent. You can say clearly, "I appreciate your concern, I'm fine. I do not consent to entry. Do you have a warrant?" Fourth, ask them directly what they need from you to close the call. Say something like, "Officer, what do you need me to do so you can document that I'm safe and be on your way?" Give them an off-ramp. Make it easy for them to leave. Fifth, record everything, every second of every interaction. Make it unmistakably clear on that recording that you are not consenting to entry, that you are communicating with them, and that you are demonstrating you are not a danger to yourself or anyone else. Sixth, if absolutely necessary, step outside briefly so they can physically confirm you're okay, but shut the door behind you. Do not bring anything with you that could be perceived as a threat. And do not, under any circumstances, invite them inside or give them consent to enter. The moment they can see you standing there coherent and unharmed, their justification for entry evaporates because the entire basis of the welfare check was concern for your safety, and you've just proven you're safe. But if they force their way in, despite all of that, do not physically resist. That is the single fastest way to give officers exactly what they need to escalate the situation and charge you with additional crimes. Instead, state clearly and calmly, "I do not consent to a search of my home or my person, and I will not answer any further questions without my attorney present." That's it for today, folks. See you in the next video.